recently, one of our potential clients, who is not currently a client, told us that they want to find somebody who's going to play tricks and dirty tricks and do what's necessary and be aggressive and fight this and fight that and go get the other side. Fine, fair enough. I understand the sentiment. Divorce can be filthy, it can be absolutely nasty. But we do not win cases by being dirty and unethical. We win cases by being thorough, better prepared, making better arguments, knowing case law better than the other side, presenting better than the other side, more coherently and more convincingly than the other side, by knowing more about the case than the other side, and by better preparing our clients than the other side. If you wish to hire a family lawyer or any other kind of a lawyer to represent you in your divorce case, and your goal is to hide your personal finances and intimidate the other side and bankrupt them in litigation, choose another law firm. Because what is ultimately going to happen is you're going to, at some point in time, be sanctioned. You are going to, at some point in time, have a massive bill for unnecessary litigation, a massive bill for unnecessary things for trying to block the other side, which it could be considered frivolous at some point. If you wish to make divorce a money pit in which you pay endless amounts of money out of revenge, that is when those stereotypes attached to lawyers, who wins the divorce case, the lawyers, which is perhaps the dumbest, most moronic statement of all time, made by people that either are so bitter they cannot think straight, see straight, or have an ounce of common sense. But this is how you do it to yourself. This is how you occasionally make that stereotype a reality, by telling your lawyer in a consultation that your goal is not to win your case. Your goal is to hurt the other side and punish the other side and hide shit and make sure they never see your finances. Okay, ladies and gentlemen, give me a break. Divorce has inherently attached to it these little things called mandatory disclosures. Does that sound like something that you should be hiding and delaying and avoiding providing? Do you really think that that's going to give you an advantage, and that the other side is not going to have you in for a motion to compel hearing, and the judge is not going to order you to provide those documents, and that that is not going to lead to additional document requests because you've been playing little dirty tricks and hiding the ball? Comply with the court's rules. That is how you win cases. You do things timely. You follow the rules. You know as much about the case as humanly possible so you can have a total outcome, not an outcome where a case is decided and then, oops, we forgot all about the house. We forgot all about the cars. Oh man, I think we missed that giant 401k. Now we have to do a retrial, a rehearing, reconsideration, whatever. The way to win your family law case is by being a better litigant. And you're also going to poison the well when you're telling the other side that you're unwilling to provide documents that you're supposed to provide. What do you think they are going to assume when you send them a settlement offer, to the extent you're even willing to do it with that mindset? We encourage settlements as early and often as possible, as long as we have enough information. What do you think the other side is going to say when you've been hiding your finances, when you've refused to give them anything, or when you've deliberately not paid a household bill to punish the other side and put yourself in the foreclosure? What do you think they are going to say, and their counsel is going to say, when you send them a settlement offer and they still wonder, well, what about that other bank account? What about that other retirement account? What about that pension you have disclosed nothing about? This represents a problem. Can I say that everything I've ever done in litigation has been, I don't know, as fair, quote unquote, as possible? Maybe not. Because when I'm in court, my goal is to win cases and represent the best interests of my client, not play pinochle and shuffleboard with the other side. That's not it at all. If you talk to counsel to represent you potentially, and what you're telling them is all of these nasty things you hope to achieve, and then you're telling them all these nasty things you hope to achieve, and what happens is, um, At the end of the day, you have to make the decision as to what kind of a lawyer you intend to hire, who you feel comfortable with, and who you feel represents your best interests. But under no circumstances am I ever going to have a client consultation and answer a call and compromise the professional, transparent, and effective way that we do business. We represent people effectively. We do not do the sand in the eyes. We do not do the blindsiding. We litigate fairly, we litigate well, and we litigate with whatever is necessary with our client consent. If your goal is to punish the other side and spend a fortune doing it, well, maybe then the other counsel that you hire does benefit greatly from it, but you certainly and most likely will not.